Let's take a step back and talk about some of those local efforts that California and San Francisco became infamous for. Local laws that were directed at making life uncomfortable for Chinese that were here. Harry?
The early days of in California were very, very hostile to Chinese Americans. The legal system just did not entice the Chinese to use the legal system that were existing in California. It probably stemmed from a 1854 decision by the California Supreme Court. In a published decision, Chief Justice Hugh Murray in 1854, writing for the Supreme Court of California, reversed a murder conviction because the key witness to that murder was a Chinese witness who the court said should have been disqualified to testify. An 1850 California law said that Indians and blacks, Negroes, could not testify against a white man. And Chief Justice Murray said that Chinese were Indians. Both were Mongolians. He had a distorted view of anthropology, that there are only three groups of races in the world: Negroid, white, and Mongolian. And then he went through the Bering Straits, the land bridge, and the Mongolians coming down, becoming Native Americans, Indians, and that Columbus made the same mistake, trying to find his way to Asia, naming the people that he saw here Indians. And he said that if we were to grant the Chinese the right to testify in a court, why, the next thing you know, they would find them in the polls, in the jury box, and maybe one day even on the bench, and in the legislative halls of the state of California. And he said the same rule that would admit them to testify would admit them to all the equal rights of citizenship, and California was going to fall in the category of saying that Chinese just could not use the legal court system, could not testify, could not serve on a jury, could not participate in the legal system. And so the use of the state courts and the political rights that are attendant to citizenship were denied to Chinese for at least the first 20, 30 years of California's legal history. So the Chinese increasingly turned to the federal courts for redress of whatever rights that they might claim against very discriminatory laws. And the Board of Supervisors of San Francisco probably was one of the most hostile legislative bodies, enacting various forms of taxes, impositions of restrictions on Chinese Americans and what they could, employment they could gain, denied the children the rights to go to public schools, and other things that were enacted in the San Francisco ordinances. But the Chinese were persistent. In one of the most famous cases, Yik Guo against Hopkins, was a case decided by the U.S. Supreme Court in 1886 that said that equal protection of the laws applied to all persons, including aliens. And that kind of set the tone for the use of the federal courts and the use of the state courts ultimately to right some of the wrongs that had occurred in this period of time. But for the first 30 years, or maybe 50 years of California's history, Chinese Americans just were barred from the use of the legal system and from the use of the political system. in California. So let's turn to 1882 and take a close look at the Chinese exclusion law, an act of Congress that not only barred the immigration of Chinese as a named race, but also barred them from any naturalization rights or citizenship rights.